Please, Lordship. Also, I beg to mention item number 19.
What?
19. May this matter may be dropped for today. 19.
They are being made by Miss
S. Dole. S. Dole.
S. Dole. Furnished appearing on behalf of Mr.
J. Pine.
By done for the day.
Lordship.
Done for the day.
Yes, yes. Keep your. Wait, please, Your Lordship. Lordship, with the consent of other side, I beg to mention item number 20. Lordship, I am appearing on behalf of S.S. Roy. Please, wait.
Your name?
J. Gayon.
J. Gayo. Furnished other side. After
Weeks. Yes. I'm okay.
May I please listing of this matter, my lordship, this pension matter, family pension matter, last listed on 12th August.
one.
Listing of this matter.
One.
8
Eight.
September.
Madam, you please go to court number 4. That is senior court.
Lordship, I beg to mention item number 5. I am for a petitioner. I have taken consent from the other side. I prefer only password for the day. Some difficult. Only for that.
You are for
Petitioner. On behalf of Misa is whatever.
Sir.
People.
Google learned left in behalf of sir.
Is whatever.
As for
Yes, Lord. Deeply obliged.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 31, your lordship. Lordship, we were informed that new incumbents have taken place of the old respondents, your lordship. Therefore, we want to impede them in this very matter, your lordship. So,
number 31.
31, your lordship, contempt case relating to pension.
You are the petitioner.
Petitioner, your lordship. I appear on behalf of Mr. Kane, your lordship. I think 2 weeks' time, your lordship, to file an IFO impeachment.
But with all the matter, it
Indeed.
May it please, Your Lord. Lordship, with the consent of the other side, I beg to mention item number 21.
What?
21.
It's your name.
F. Begum. Any date for only.
Please, your lordship. I am no longer in this case, lordship. The petitioner has for NOC from me, I have already given them. They will engage another counsel.
Where is your appeal?
My lord will bring it. My lord will bring it on record. We have about to give him today, my lord, because we have got it from signing. My lord, we have sent it for signing. So since he is not there, my lord, we'll have to give it to the new council now. So we can't file it because we have to give the petitioner's council. There is no petitioner's council because he is given NOC. Man.
That's right, but whether your affidavit is ready,
The affidavit, my lord, contains only those 3 documents which lordship I had given on the last occasion. So that only has been brought on record. So my lord will give fix it on some after, my lord, after 2 weeks maybe. In the meantime, they will definitely engage some counsel most probably. Then we can give it to the council, concerned council.
but our right, and you have
Not.
fine. Affidavit five and six.
My lord,
Obliged.
deeply obliged.
May it please your lordship. My lord, in this case, petitioner applied for the post of recruitment for the recruitment really held in the year 2011 and 12, my lord, in Assam Rifle. Accordingly, my lord, he has passed the test, my lord, physical test. Thereafter, my lord, he passed written test, and finally he passed medical test, my lord. And on my lord, 12th September 2011, my lord, he was appointed, my lord. Annexure 1, my lord, page 12. Thereafter, my lord, he was sent for
After
my lord, in the item number 4, my lord, I request, my lord, a similar matter is referred for mediation, my lord. That is fixed on 16th September, exactly similar. So may I pray, my lord? Last time, my lord, it was listed for mediation only, but I could not present my last date, my lord. So may I pray, my lord?
My lord.
19/8/2025, it came, my lord, for mediation, my lord. On that day, I could not present.
no, you tell me, can we refer the matter to the mediation now?
Last occasion came, my lord, and similar matter is fixed for mediation, my lord. I have,
No, you tell me whether we will refer the matter to the mediation or not.
my lord, can many matters are referred.
We refer this matter.
My lord, last occasion it came for mediation, so I could not present. And similar matter is pending on 16th September for mediation. I have the WPC number
Or you
My lord, may I?
4539.
May I, my lord? In this case, my lord, one is the party is Union of India, Ministry of Home Affairs from Delhi, my lord.
Oh.
And document number 1 is Union of India, Ministry of Home Affairs. This comes from the Delhi, my lord. And the another is respondent number 2 is from Shillong, my lord. This case mediation may not be possible, my lord. Matter my heart, my lord.
My lord, they have already filed affidavit. And similar matter, they are coming from Shillong, my lord. They have appeared, my lord.
Otherwise, my lord, they have no case, my lord.
My lord, that will be later on decided. But they have come from Shillong, my lord, in WPC number 4539/2018. It is pending on 16th September. And my lord,
Go to the mediation.
many people are also getting, my lord.
Action, my lord, this case in mediation may not be possible in this case, my lord.
Why?
Their only claim is that pensionary benefit due to his retirement, my lord, due to some medical condition, my lord. Our side is that, my lord, the medical condition, whatever she stated, my lord, that is not attributed in the period of his service, my lord. She is some different person, differently, my lord. Not attributed to the service, related to the service, my lord.
My lord, I have
Lordship,
some
it's upon your
documents.
lordship, my
These persons are also getting, their process is going on, similar matter, my lord. Process is going on, my lord, department has,
If they are not, madam, if they are not willing to go for mediation, then we cannot compel them. We'll hear the matter then,
not today, my lord.
not today, okay, okay.
My lord, he is not the CJC, I think, my lord.
I am
You
on
are
behalf of
very-
DC Bora, my lord.
He
DC Bora.
is not the concerned CJC, my lord, so his consent cannot be taken, my lord. Mr. DC Bora, he has already filed affidavit, my lord. So
I am
how
on behalf
can
of DC Bora, my lord. He is not well, my lord.
so how can he can submit that it cannot be
They
there?
are on inspection.
Yes, my lord, I have instruction.
Hard is as per that.
My lord.
Lord, hard is that.
KM Hassan on behalf of DC Bora.
M. Hassan, Lord, President, we have DC, that
DC Bora.
DC Board, Lord, CGC. Total Lord, company product instead. Similar method has already been referred for mediation. This matter may also be referred for mediation, referred for mediation. But Mr. Hassan Lord, counsel evident for the Lord, no purpose will be served by referring this matter for mediation, price for matter for hearing. According to the of the top, the party, provided that this is a list of matter for hearing.
Can we do that? My lord.
Obliged, my lord.
My lord, he was appointed, my lord, on 12th September 2011, Annexure 1, page 12, my lord. After passing all the tests, my lord, physical, written, medical. Then, my lord, he was sent for training in February 2012, my lord. When he was doing the training, my lord, during training, my lord, he fell down, my lord, because of dizziness. When he was admitted in the hospital, my lord, he was detected a disease that is called seizure disorder, my lord. And finally, my lord, Annexure 2, page 14, my lord, he was discharged from service on 31/12/2012, my lord, page 14. In the discharge order, my lord, it is clearly written that discharge from service on medical ground. And my lord, my submit and next page, my lord, page 15, my lord. Here also, my lord, ground for discharge on medical ground. In their affidavit also, they have stated that because of medical ground, because of this disease, I was discharged from service, my lord. And here, my lord, I am praying for disability pension, my lord, because, my lord, in their affidavit, my lord, kindly see in all the annexures, they are saying that recommended to be invalidated out from service in low medical category, that is P5, my lord. Everywhere they are stated. Now, my lord, I am praying for disability pension. As per rule, I am entitled for that, my lord. I have the Supreme Court judgment, this Honorable Court judgment, and rule also I have. But they, in their affidavit, they are saying that it is because of medical ground, but I am not entitled because my disease, seizure disorder, is not in the rule, my lord. Name is not in the rule, my lord. But in fact, rule is not that, my lord. In my affidavit in reply, my lord, I have annexed, my lord, this Honorable Court judgment, one division bench judgment also, my lord, where, my lord, it is clearly stated that, my lord. In fact, my lord, if it existed before also, because at the time of entry, no, my lord, disease was detected, meaning thereby, my lord, at the time of my lord entry, I am hale and hearty, my lord. If I am detected any diseases after enrollment, my lord, it will be, my lord, held that because of the, my lord, medical category, because of the disability or any disease which I have developed, my lord, after enrollment, I am entitled for that, my lord. My lord, kindly see my affidavit in reply, my lord.
Page number.
Affidavit in reply, my lord, annexure 1, page 63, my lord. Exactly similar order, my lord. Here, my lord, single bench allowed the judgment. And my lord, they have department has approached the division bench. And division bench held that, my lord, he will get. Even it existed before also, my lord. Relevant, my lord. Page, it starts from page 66, para 7, my lord.
That was the case of injury.
Injury, my lord.
How this judgment will help him?
No, my lord, that was, my lord, there in their bone fracture, my lord.
There he suffered, my lord, fracture during training. So during training, he was injured. And
Here
suffered-
also during training, he developed that disease, my
Here it
lord.
is a disease of seizure disorder, my lord. Seizure disorder is not attributable to the service, my lord. As a result of training, it has not been caused to the deficiency.
But my lord, in their affidavit, kindly see, my lord, they have everywhere written because of this disease. And next time, my lord, their affidavit in opposition, my lord, page 26, kindly see. Page 26, my lord, disabilities, seizure disorder. And recommended to be invalidated out of service in medical category P5. Then, my lord, annexure 5, page 29. Disability seizure disorder recommended to be invalidated out of service in LMC, page 25. Then page 35 also, my lord, medical category awarded recommended to be invalidated out of service in LMC 5. Then page 36, my lord, their discharge order, discharge release from service on medical ground in respect of so and so. Everywhere they have stated that because of this disability, I was discharged from service, my lord. But now they are saying that I am not entitled. Then, my lord, I have annexed one judgment, my lord, in my affidavit in reply. Annexure 2, my lord. Kindly see page 68. This honorable court, my lord, held that even if it is not attributable, even he is discharged on medical ground, he will get. Because at the time of entry, no such disorder was, my lord, recorded. My lord, may I read page 75 of my affidavit in reply?
Yes.
My lord, para 11, now coming to the case in hand, it is seen that medical board has not recorded any reason for concluding that disability was not attributable to the service, inasmuch as from the said report, it is clear that at the time of entry in the year 1983, petitioner was not having any psychiatric disorder. Here also same disease, my lord. From a bare reading of Rule 3 of the Rule 1939, I have got the rule also, my lord. It is clear that it is presumption in favor of the employee. The said rule prescribes that when a disease is detected during government service and remains aggravated, the same is to be deemed to be accepted as arose due to the government service. At the same time, as discussed above, the law is also equally well settled that even the presumption is to be effected when at the time of entry into service no disease is recorded, it is to be presumed that such disease has to be acquired due to the service in the armed forces. Therefore, the argument of the Union of India and the reason of rejection of the claim of the petitioner relying on Rule 3A of the Rule 39 is not sustainable in law, more particularly in view of the presumption prescribed and admitted fact that case is hand is that the disease was not detected at the entry into service, but the same was detected during the course of service, and same was aggravated, resulting the discharge of the petitioner after rendering more than 8 years of service. Regarding the qualifying service of disability pension, the court is on the considered opinion that Rule 49 of Rule 1972 shall not be applicable in case in hand for the reason that pension claim was disability pension and not an invalid pension. Inasmuch as for grant of disability pension, no qualifying period is prescribed, my lord. Another important aspect of a matter is that there is a difference between invalid and disability pension. Then, my lord, para 15, the qualifying service mandate for Rule 49, 1972 shall be applicable when an invalid person is, or here, my lord, difference is given what is invalid and disability. In invalid pension, my lord, length of service is required, but in disability pension, no length of service is required, my lord. In case of an
provides the same,
my lord,
which rule provides the same?
Rule 3, my lord, I have the book. Here, my lord, rule is also quoted. Extraordinary pension rule, Rule 3A, my lord. Yeah. Rule 3A, my lord. This rule is quoted in this judgment, my lord. And my lord, Honorable Supreme Court very recently passed an order, my lord. If at the time of entry no disease, no injury is detected, you will definitely get the disability pension, my lord.
Where is that document?
The judgment just now, my lord, I have brought. So, my lord, my case is very, my lord, well settled. And my lord, many persons are getting, my lord. All, my lord. Injury or disease, whatever, my lord, if they get after, my lord, just. Here, my lord, all the Supreme Court decisions are, my lord, referred.
Okay. So, Gupta, what is your stand?
My lord, my stand in one of the judgments which have been referred, they are distinguishable on facts. The first judgment, my lord, that was he suffered an injury during the training, my lord, that with a division bench judgment which the petitioner has pointed out. So there was a fracture, my lord, during the training. So that, my lord, perhaps
That may be, but there is
attributable.
no,
This
the judgment referred by her, there is another decision. So, Pension Singh versus Union of India reported in 2041 as the 361.
Achha.
And many judgments are, my lord.
Lord, the
the disease should be attributable to the my lord, because what has happened here, my lord, he was a trainee. During the training, he suffered the disorder. So far as the claim of invalid pension is concerned, that is automatic. Obviously, they will not be entitled to, because minimum 10 years service is not there. Now, for the claim of disability pension, my lord, under the TCS Extraordinary Rules 1939, the disease
CCS extraordinary.
Yes, my lord. Central Civil Services Extraordinary Pension Rules 1939.
I have just given that rule.
Okay.
My lord, that defines, my lord, injury and disease is,
Section.
my lord, first I would refer to the definitions, my lord. That is section 3, subclause 3, which defines injury. Injury means an injury as is mentioned in Schedule 1 here to annexed. Permanent total disablement shall be deemed to be the result from every injury specified in Part 1 of Schedule 1 or from any combination of injuries specified in Part 2 of that schedule where the aggregate percentage of loss of earning capacity amounts to 10% or more. Every injury specified in Part 2 of Schedule 1 shall be made to result in permanent disablement. Now, my lord, the definition of disease. Disease means a disease as is mentioned in Schedule 1A here to annex. Now, my lord, coming to the definition. Sorry, my lord, the main part, section 3A. My lord, section 3A says, my lord, disablement shall be accepted as due to government service provided that it is certified that it is due to wound, injury or disease. Now, my lord, here there is no injury. Here, my lord, what is the seizure disorder is a disease, and that disease, my lord, should be there in Schedule 1A, which is attributable to government service or existed before or arose during the government service and has been and remains aggravated thereby. So, my lord, the first condition, that is, it is attributable to government service, is not fulfilled. And secondly, my lord, that disease is not mentioned in Schedule 1A. If my lord will take Schedule 1A, there are list of and classification of diseases which can be contracted by service. In those diseases, my lord, there are certain categorizations made, that is diseases affected by climatic conditions, diseases affected by stress and strain, then, my lord, diseases affected by dietary compulsions, diseases affected by training, marching, etc. Now, he was, my lord, discharged during the process of training, and environmental diseases. So, in none of those categories, my lord, the seizure disorder is there. And if we refer more specifically to the diseases affected by training and marching, there also, my lord, seizure disorder is not mentioned. So what is not there in the, my lord, statutory provisions, my lord, every kind of disability would not entitle a person to claim a disability pension. It has to be attributable to the service, and the nature of the disease should be there in the schedule. And the second case, my lord, which my learned has referred, single bench order, that was, my lord, regarding the qualifying service. That for disability pension, qualifying service is not required. Both the judgments are distinguishable, my lord, in the present facts of the case.
My lord, may I
Did you feel that if there is if the disease find no mention in this schedule, the petitioner will not entitled to disability pension?
Yes, my lord, that was the, in fact, that is the ground on which the, my lord, the claim was rejected. If my lord takes annexure 3, page 16, paragraph in view of the above, page 16, my lord, annexure 3. In view of the above, it is to inform that your disability seizure disorder is not covered under Schedule 1A of CCS EOP rules. Thus, you are not entitled to disability.
My lord, may I submit?
Let him.
So, my lord, in my humble submission, first of all, my lord, it is not a disease which is mentioned in the schedule. And secondly, the conditions described under the statute, my lord, under section 3A, my lord, which says that the disease should be attributable to service. That condition is also not fulfilled. Because, my lord, this is an extra pension, my lord. Normally, what happens, my lord, if after joining the service, my lord, somebody completes 10 years of service, yes, in that period, my lord, if he suffers some disability, my lord, he gets invalid pension. Now, disability pension is in addition to the invalid pension. So therefore, my lord, this is a special statute and the conditions.
Do you answer my question? If the name of the death is fine from the schedule 1A,
Yes.
whether the petition can be reviewed.
My lord,
Yes, my lord, because my lord, the section, the provision says so, my lord, because if, my lord, if I may read the provision again, disablement shall be accepted as due to government service, provided that it is certified that it is due to wound, injury, or disease. Now, disease, my lord, is defined. That disease means disease as mentioned in Schedule 1A here too.
Mm.
My lord, beyond that, my lord, because statutorily it is provided unless the government has modified those, amended the rules by including other forms of disease. And diseases affected by training and marching, which I have read, my lord, Schedule 1A, seizure disorder is nowhere mentioned. And secondly, my lord, it is not attributable to government service. So it will not be, he will not be entitled to
Not attributable when it was detected during his training.
Yes, my lord. My lord, in the findings, the medical board findings, my lord, that finding has also been reached.
That page number,
That page 33, that was assessed by the, my lord, medical board to determine whether it is attributable to service or not. Page 33, my lord.
33 of his petition.
For the affidavit in opposition, my lord.
Yes.
My lord, the first part 3 says, my lord, does the disabilities exist before entering service?
Page number 30.
Page number 33. Point,
33 is the
medical board proceedings, my lord. It is part, it starts from, my lord, page 29. Page 29, annexure 5. And the relevant portion is start page 33.
annexure R2,
R5, my lord.
R5.
R5.
Yes.
My lord, you'll see, my lord, at page 29, R5, my lord, in the first page. Was the individual, as far as you are aware, in his normal health prior to the onset of the illness? But the answer to this is, as per the individual statement, he is suffering from this disability from the age of 18 years. Similar, prior to the training, he was having that disability. It proves that, my lord, it is not attributable to service.
That is the statement. Is there any medical support?
Yes, thereafter, my lord, this is the statement, and thereafter, my lord, page 33. No, my lord, page 30. Page 30, my lord, paragraph 5. So this is the finding of the, my lord, the training officer. Initial finding, my lord, thereafter I will refer to the board proceedings. Page 30, do you consider that the death or disability was attributable to or disability aggravated by service? My lord, the findings by the, my lord, the commanding officer during the training is no. Now, my lord, page 31 is the medical board proceedings. Page 31. Page 31 is the medical board proceedings invalidating in low medical category. Here, my lord, we come to page 33.
Mr. Gupta, there is a mismatch about the designation. It is before the Annexer R5 or after the Annexer R5?
After annexure R5, my lord.
R5.
In continuation.
Okay, medical board proceeding. Yes.
Yes, medical board proceedings invalidating low medical category.
Yes.
Here, my lord, my lord, next page, my lord, page 32, sorry, page of that invalid board proceedings, my lord. In case of wound or injury, state how they happen, whether or not. So here, my lord, there was no injury. The findings of the board is no. Then, my lord, will come to next page. At serial number 2. In respect of each disability, the medical board on evidence before it will express its view as to whether it is attributable to service during field or under field service. The answer to it was no. Whether it has been aggravated or remains so, no. Whether it is connected with the service, no. And then, my lord, the board should state fully the reasons in regard to each disability on which the opinion is based. So here also, my lord, it has been said that the disability is not attributable to service. One of the findings of the medical board was clearly that the disability was not attributable to service. And initially, my lord, the petitioner himself was accepted during training that he was suffering from disability from the age of 18 years.
Except his own statement, do you have any other material to prove that such kind of disease cannot be attributable
Lord, the medical
to the
board,
service?
my lord, this is what is normally done, my lord. Medical board proceedings are done, which is certified.
Right, but medical board proceeding shows that it depends upon the statement of the petitioner.
No, my lord, there are two.
Since 18, he has been suffering for the same.
No, my lord, there are two things. My lord, the first one which I have read, uh, my lord, that was during the training. And the second one which I have read, my lord, that is a medical board proceeding, which comprises of, my lord, uh, three doctors, my lord. There is a presiding officer of the medical board, then member of the medical board and the medical officer. That is 21/8/2012. They are specialized, my lord. These three doctors, they are specialized doctors and they come to a finding. They have given that finding that it is not attributable to service. The first part which I,
Whether they have conducted any medical test to determine the disease. Except it is a clinical examination.
look, that I have to, Lord, from the records, because this is the findings of the board. The records would reveal all those tests. This is the final board.
Going by this board proceeding, can it be said that any test was conducted?
Lord,
Going by this board proceeding,
my lord.
can it be said that any medical test was conducted?
Yes, my lord. Tests are conducted, my lord. That is
Where it is stated?
subsequent to that only these board proceedings are made.
But where it is stated? What are the tests they have conducted before arriving at such a decision? I think.
That my lord, to have the records would reveal, my lord, because this is the final.
Now we see the board proceeding.
My lord, page annexure R4. The tests were conducted, my lord. Page 26. Page 26 and 27.
So board proceeding part 1, part 2, part 3, in which part it is stated?
Yeah. My lord, page 26, annexure R4.
Yes.
No, that is the medical case sheet of the petitioner. He was examined by the my lord, classified specialist and neurologist in Kolkata, my lord. So here, February 2012, seizure disorder, The history is given, my lord, an examination was done. And my lord, in the impression, it has been given that in view of two episodes of a GTCS and abnormal EEC record, he has been started on AED, which has to be taken for a period of 2 to 3 years without seizure recurrence. In view of the above and the recurrent nature of the deceased, he is not fit to continue in service training to be invalidated out in the medical category. Pursuant to this finding, my lord, the board has, my lord, come to an opinion. Findings are done. On the basis of this examination, the board has come to a conclusion.
See, it's hard for
No,
it's a
no,
suggestive of the word, suggestive of location, reflected epilepsy. So the word confidential.
my lord is reading the impression type copy. That is command hospital, my lord, medical case sheet. My lord is reading.
Yes,
Yes, my lord.
the before the line before the confidential, word confidential. Suggestive of it.
Yes, my lord. Suggestive of localization related epilepsy.
And post-traumatic epilepsy is there in the video. Page number 43.
So that is that should be resulting from skull injury, my lord. Post-traumatic epilepsy and other mental changes resulting from skull injury. You know, there has to be injury, my lord.
Is affected by training. I think that's it.
Yes, my lord, during training, if someone suffers a head injury and then, my lord, it leads to post-traumatic epilepsy, my lord, then it is covered. Here, my lord, it is a case of a normal seizure disorder, which is not attributable to service. So, my lord, it has to be attributable to service in any form, my lord, whether as an injury, after the injury, the disease should come, or, my lord, the disease should be of such a nature which has been caused, my lord, as a result of the training.
Okay. Any other point?
So that is the,
Yes, what is your answer?
My lord, my first, my lord, answer is that, my lord, kindly see their own affidavit, my lord, R5. Disability, my lord, severe disorder and percentage of disability 20 to 29%. As per Supreme Court judgment, my lord, if I have got that judgment, I have given 1% disability also, I will get the disability pension. Secondly, my lord, to be invalidated or recommended to be invalidated out of service in LMC 5, low medical category 5. If I am low medical category because of medically unfit, my lord, it must be, my lord, because it is attributable. Secondly, my lord, to be, my lord, if you are aware of any previous illness from which he suffered in his medical state, the nature and duration, no, he is not aware. Secondly, my lord, again, my lord, kindly see, their part 3, my lord, page 33. Does the disability lies exist before entering into service? My lord, no. Answer is no.
Which part?
Their affidavit and position, my lord, page, I think, 33 and 50 both they have written. Does the disability lies exist?
The part E.
Part
Is it in the part E?
yes, part 3, my lord. 33 page.
Part A.
Part 3. Roman 3, my lord. Does the disability lies existed before entering into service? The answer is no, my lord. Means, my lord, it is aggravated by service conditions. And, my lord, as per law, my lord, if it is attributable or, my lord, existed before, kindly see the rule, my lord, 3A. Or existed before, or is also there, my lord, or existed before. Meaning thereby, my lord, I will get, my lord, even if it is in the previous time. And they have counted my disability, my lord. In the discharge order also, they have stated I was discharged on medical ground. Secondly, my lord, they have said that my seizure disorder is not in, may not be, exactly that name may not be, my lord. But kindly see, my lord, head note B, my lord. Disease affected by stress and strain. B, my lord. Disease affected by
Which one?
stress and strain. Book, my lord. Schedule 1. He has said that my disease is not in the book.
Schedule 1. B.
B, my lord. Disease affected by stress and strain. My epilepsy comes, my lord, under this.
Which one?
Disease affected by stress and strain. Because, my lord, it is a seizure disorder is a condition in which a person has multiple seizure, and it is because of stress and strain. Under head B, my lord, disease affected by stress and strain. My disease will come, my lord, under this. And as per my lord, Supreme Court judgment, my lord, if I have got 1% disability, also I will get. And if my affidavit in reply, my lord, second annexer 2, my lord, which I have annexed, here also that person also suffering from the same mental disease, suffering from non-organic psychosis. This is also just like epilepsy, my lord. I have searched, my lord, suffering from non-organic psychosis. Same stand was taken by them, my lord. But Honorable Court rejected, my lord, said that even if they have said that it is not attributable, Honorable Court held that if it is, my lord, after entering the service, my lord, it must be aggravated by service condition, and my lord, he will get. Here, my lord, Honorable Court has clearly written, my lord. And, my lord, many Supreme Court judgments were also here, my lord, referred. Para 12, my lord, from a bare reading Rule 3 of Rule 1939, it is clear that there is a presumption in favor of the employee. Said rule prescribes that when a disease is detected during government service and remain aggravated, the same is to be deemed to be accepted as errors due to the government service. At that time, my lord, as discussed above, the law is equally well settled that even the presumption is to be effect that when at the time of entry into service no disease is recorded, it is to be presumed that such disease has to be acquired due to service in armed forces. Therefore, the argument of Union of India and reason of rejection of the claim of the petitioner relying on Rule 3A of Rule 39 is not sustainable in law. More particularly in view of the presumption prescribed and admitted that the case is and that disease was not detected at the entry into service, but the same was detected during the course of service.
Okay. Mr. Gupta,
My lord.
you come to part 3 of the report from the
Yes,
part 3.
yes, ma'am.
The question number 1, does the disability exist before entering service? Answer is no.
Yes. Yes, my lord, that obviously, my lord, when the authorities examine, they will have to give that finding because they also don't know that this disability, whether before entering service.
Then how can you deny?
Then
No, but the fact, my lord, that the attributability, my lord, that it should be attributable to government service because this is an extraordinary pension, my lord, an additional benefit which a my lord, employee would get. So, to get a special benefit under the extraordinary pension rule, that disability must be attributable to service. If that is not attributable to service, my lord, in that case, any disease, my lord, person will claim disability pension.
No, Mr. Gupta, if you're finding this question, does the disability exist before entering service? No. Then
Yes, my lord, before entering service, because they also don't know, my lord, that finding can obviously.
then Mr. Gupta, there's a decision of the Honorable Supreme Court in Bhupinder Singh
Yes.
versus the Union of India 2014 1 section 64.
and so many
This
judgments.
presumption has to be drawn in favor of the petitioner that he contracted the disease after entering into the service. Okay,
Not one,
we'll pass the order.
not one judgment, my lord, I will
You,
just,
you can refer.
one, I will just, my lord, leave.
My lord, two more judgment may I submit?
No.
Not yet. And in my lord, my second annexure to affidavit in reply, my lord, last, my lord, kindly see page 72, last, my lord, page 72, annexure 2, my lord. Affidavit in reply. Here it was the further contention of that the petitioner is also not entitled for disability pension under CCS rule as the disease was declared not attributable to or not aggravated by service condition. They have taken same stand, my lord, in that case also. In spite of that, my lord, Honorable Court has allowed annexure 2, my lord, of my affidavit in reply, page 72. Obliged.
No, one judgment I will give, my lord, paragraph,
Mark the paragraph.
I will mark the paragraph, my lord.
My lord, in this case, I am seeking a little accommodation to them, my lord. The file has been misplaced in the office, my lord. If this matter was kept for CAV, thereafter the clerk has actually put the file somewhere else, not place out the file. My lord.
My lord, I am appeared on behalf of College Authority, my lord. College Authority as well as all students are suffering due to non-appointment of the teacher, college teacher. Already selection is over. And due to this case, my lord, whole students are suffering, my lord. So matter is taken on Friday, my lord, at this, my lord.
Wednesday, next day.
Wednesday, Lord.
Week.
Malad, it was kept CAB Form 2/3/2023, Malad. I am so unlucky, Malad. So let it be on Wednesday or Friday, any day, Malad.
Next week, my lord.
Okay, part is a ticket, not part. That's but it's not like
I don't know, need to put one thing in the committee.
Friday, my lord, Friday. My lord,
My lord, next
I
week,
am behalf of
next,
College Authority with, my lord, respond number 3 and 4.
yeah.
আমি দিও কপি লাগিলে
PD দিয়ক এটা status.
It's the task learned it's the next of for the content higher part. It's not after the week. And it's according to the exactly.
on Friday, Malad.
Coming Friday.
Friday, Malad.
Friday.
next
Friday.
week, next
You
week will be.
Friday, Malad.
provide the document.
If required, Malad, we'll copy furnish to him again, Malad. Friday, it may be.
Affidavit also. Affidavit.
Everything is clear, Malad. We will give a copy to him as it is copy, Malad.
My lord, 1 week will be, my lord,
We'll give the copy, my lord.
at least 1 week. my lord.
Let it be a next Monday.
Monday, I will be not available, Malad. Some.
Any date.
Malad, Friday, it will be better, Malad.
Tuesday. Oh, yes.
My lord, you have to.
I will submit copy to him, entire copy to him, Malad. Entire copy. He has filed a.
Any day next week, my lord, because we have to prepare also the file. Already,
Nine of
we supplied
No.
many judgments there.
No, 11, 9, then.
11.
Sorry.
No. I apologize, my lord. Extremely sorry, my lord. I was earlier, my lord, I instructed not to appear, my lord. Now, my lord, he's my lord, instructed me to appear the case. Proceed the case, my lord. Only because of that, I have not filed my lord the petition.
Are you ready to argue the matter?
But I'm ready to argue the matter, but affidavit has not been filed.
Affidavit is ready, Lordship. Within two days, we will file affidavit, Lordship. Kindly.
Or the order. And I don't know name please.
S. Borua
That's Purva,
for respondent number 1, 6, and 3, 8.
1, 6, 8. Norma 4.
4.
4. What submits? No. It was directed by the order dated 26/2025 to file an application to withdraw the here. Now he has instruction to appear before this court again. And as such, he has not filed any petition before the registry as Friday. Ms. Borua Lodai,
Time to
copy for the respondent number to submit or affidavit is ready and will be filing within detail from today. Accordingly, it is provided that this is the matter on next. Or that
Deeply ordered.
Complaint.
Deeply ordered. Oh, no, it is.
Your lordship. In this matter, the state government has not filed their affidavit yet. Your lordship.
also filed the affidavit?
Respondent note 3 has filed the affidavit, 1 and 2 has not filed it.
One and two. Wait for 1 and 2. Health and Family Welfare Department. Anybody attend for Health Department? Eight, nine. Mr. Goswami, are you appearing in this matter?
No, Lordship, here is, I am not appearing.
Family Welfare
SC Health is there, Lordship. We are informing us.
Wait for some time.
Health, Lordship.
May appeal. This is a case regarding a appointment of Gawura, Your Lordship. Interview was held in the year 2019. Thereafter, no result has been declared. And earlier, we approached this honorable court and case was disposed of, directing, because they have instruction that they will advertise, declare the result. Accordingly, the petition was disposed of, Your Lordship. But till date, again, we have to file it. Your Lordship may see the page 62, Your Lordship.
PTC.
Here, para 3, upon instruction, Mrs. R.B. Bora, Learned Counsel for the authorities in the BTC, has made a statement that meeting will be held on 14/11/2022. Thereafter, the result would be declared. But after that too, till date, no result has been declared, Your Lord.
Lordship, PNAG appear for this matter. He's on legs in court 1. Sometime may be granted, Lordship.
Today?
Lordship, after some time. Obliged.
May it please your lordship. In this matter, my lord, we are led by Miss B. Bhuya, my lord, senior government advocate, senior advocate, my lord. She's on legs, my lord. She's coming. Password for the time being, my lord. Oh, yes. Lordship, in this matter, my lord, my file. Petitioner is a retired government employee, my lord. He retired as a deputy director, assistant director, director of food, civil supplies and consumer affairs, my lord. He retired on 36/15. What happened, your lordship? He was promoted from the post of inspector to superintendent, lordship, on 09 May 2009. And he joined on 4 to 2012, lordship. Lordship, may kindly have a look at annexure April 26, my lord.
But whether the affidavit was filed?
Yeah, Lordship.
No affidavit as of
Lord,
now.
Lord, yes. Lordship, I received the instruction, Lordship. So, and I will file an affidavit. Kindly accommodate me 2 weeks time, Lordship. I will, in the
Lordship,
meanwhile, I
in
will.
short date, Metro 2023, the person retired in the year 2015 itself.
2 weeks,
He
Lordship.
didn't get his,
Mr. Goswami,
Lordship.
I will grant you what I tried you filing. Did you already receive?
One,
that?
1 week, Lordship. 1 week, maybe difficult, Lordship. 10 days,
Okay,
Lordship.
10 days.
10 days.
prefer, Lordship, fixed date, my lord.
RS Jagdish. And we will make on the record. The state inspector like definitely. That is like. It will be allowed. On
Lordship, affidavit will also be required from the finance department because they have done the needful food and civil supplies, but approval of finance department is awaited, your lordship. So, lordship, from them also affidavit will be required. No, they are a party, they are a party.
Three.
Respond number 3.
Three. Respondent three.
So hard, so we have number
11.
Here, we have not received the, we are not aware because our names are not reflected there.
Item
So,
11.
madam, if you have extra copy.
I'll give a copy to him.
Oh,
11 so we have heard
Lordship, it was given in the year 2023. HLE, you received
the
it.
copy has any.
You received it.
it part
No, no, no.
I'll furnish a copy to him.
extra copy of the picture.
No matter.
Yeah, undertaking part is a copy of the same.
11 comma.
Sir, copy have. The third and we also fight the.
Yes. Areas.
Did this anything? Lordship, their name may be shown.
Lordship, instructions or because matter retains to arrear salary, Lordship. So the parent, so maybe if required, we'll file an affidavit.
No.
Or
Concurrence is not given by them, finance department.
yes,
That's the
concurrence
issue.
has not been given. I'll state the reasons why we have not given, Lordship. For that, if
Let them file their affidavit. Again, it will be
Lordship,
delayed otherwise,
I'll
my
have the
lord.
instructions, Lordship. That will be equivalent to Lordship.
Okay,
Yes, because there is a short time. Lordship.
they may file it if so advised.
Their name may be shown because
Yes,
they may.
names are short, Lordship. I apologize. That is.
So copy have heard it. Okay, the finance department, that was the- no, sorry, all this.
Obliged.
Item 11 को कम ना पालूंगा यार वहाँ पे मौन
Copy the video.
Lordship, 3 weeks time will be granted to file affidavit. We have not received any instruction, therefore could not file any affidavit.
That may be fixed then, my lord. 23 method.
The party will learn it. Or they will learn it in the same way, so nothing. Which side?
3 weeks, Lordship.
No, which time to obtain inspection. Where is according to allowed rest of the matter after 2 weeks. Obey.
Oblige.
Obliged, Lordship.
My lord, in this case, petitioner is praying for regular scale of pay. The fact is that, my lord, he was initially appointed as an assistant teacher, percentage selection process. Through petitioner, page 34.
Instruction.
Mr. Talukdar, you have filed your affidavit?
No, my lord, we have received the instruction, my lord. As per our instruction, my lord, the petitioners are irregular teacher, my lord. That's why, my lord. So, and subsequently they are accommodated as tutor, my lord, both the petitioner, my lord. So, if you lordship permit me, my lord, I will bring on record by way of affidavit, my lord.
My lord, affidavit has been filed by the department, education department.
It is full of.
File.
They have annexed the cabinet memorandum, which is under challenge at page 51. They are supporting the cabinet memorandum, but stand of the finance department is yet to be
No,
come.
Lordship, here we'll be relying on the affidavit of the education department because they are the employers, Lordship. On the basis of the affidavit filed by the education department.
My lord, affidavit filed by the secretary, my lord. The annex the office memorandum, my lord, regarding illegal irregular teacher. But I have received the parawise comment and instruction, my lord. As per my instruction, my lord, bunch of my lord annexer is there, and in this bunch, my lord, they are subsequently accommodated as tutor, my lord. As they are also joining report also there. So lordship. No, no, it is.
Whether you are interested to file affidavit or.
Some to beleg no answer. Lordship may peruse the parawise.
Secretary has filed, education department, government has filed. So whether Subsequent affidavit is
Okay,
required.
this is the instruction that has been furnished to the finance department from the education department that my learned friend wants to bring on record, Lord.
Then let the director file this.
My lord, it's better, my lord.
Or- and then put the hard submit alert or that's what the number.
Respondent.
Yes, so number 1, 2,
The file का करना है, तो तो नहीं है.
director. 3, my lord. Filed by the 3, and I am appearing for 1, 3, 4, 5, 6, no, 6 to regular LR. Judicial Department. Government.
Okay, now for number 2. Anybody for alert?
I'm appealing your tip.
The support or that the that's one number 6. The alert. Yes, Talukar submitted from the respondent number 3.
It
And
was
he will make the same record by and that that's one next time.
One.
my lord, 3 weeks, my lord.
2 weeks.
Or 2. As your lordship, or lordship immediately after vacation. To the vacation.
For vacation, you find the other. After which Mr. Odehal learned total products number that he will be relying upon the I whether that's one part. Accordingly, this provided that this method on
That may be good.
yes.
Lordship, Lordship, can I, the instructions?
May I please, Lordship? The matter relating to regulation studies of the petitioner. The last occasion, the education department has taken time for obtain instruction regarding the matter, regulation of the service. Lordship, this matter was pending for so long, 2 years for approval of the finance department. Now, finance department has approved the matter as per this honorable court's order dated 18/8/2025, where it is reflected that the finances are already been granted approval. So, Lordship, it's up to the Director of Education to comply the order. So, some because they're unnecessary, they're taking time. So, certain and the process to be completed within certain period of time.
My lord, up to date instruction, I don't have, my lord. Today morning, I have received one instruction, my lord. Director has forwarded, communicated to the District Elementary Education Officer, Kamrup, my lord, regarding the vacancy position of Devasaran Das and Madhu Sarkar, my lord, of grade 4 employee, and retention number, verification proposal, along with course creation number, etc., my lord. That instruction, my lord. And as per my telephone instruction, my lord, the process is going on. So he asked to apprise before lordship that sometime 15 days or because
The time period may be fixed.
last occasion financial
Already been approved.
already approved, my lord. So
After regularization. No, after approval of the proposal for regularization by the finance department, what remains to do?
my lord, that
Actually, the Lordship, thereafter the Director Elementary Education Department to pass an order. Because Lordship, kindly turn up with page my repetition 124, Lordship, where it is written.
134.
Yeah, page. Annexure 26, page number 124. Just regarding the decision already, because finance government was some already given the approval also. Now here it was written that para 2, the director elementary irrigation Assam shall issue necessary orders of regularization in the.
I pray for 1 week time, my lord. In the meantime, I will place the concrete instruction, my lord, regarding their. My lord.
Now, only the director of elementary
have
irrigation to
that,
take steps.
But,
But they are taking time, unnecessary taking time.
Doctor, you see, this order was passed on 28th July of 2020.
my lord, my lord. So,
More than 4 years elapsed. You are
because if your lordship dispose of the matter today, my lord, then nothing, then same will happen, my lord. So, kindly allow 1 week time. If not given, my lord, then lordship may
why
pass
do
it.
they send verbal instruction today? We will take it up at 2 o'clock.
Or tomorrow, my lord.
No. Tomorrow again, someone will appear on your
No, no,
behalf.
I will appear, my lord. I said no.
Time.
Man, I will appear, my lord. I said I will appear, my lord. My lord.
Not tomorrow, lordship, then day after tomorrow, then.
Day after
Tomorrow.
or day after, or day after, after depart. The doctor substance and that takes time to obtain necessary instruction in respect of the order.
The financial letter kan
20th July 2022 by the State Pensionary Department Disport,
no, এখন পঠাই দিব হ'ল
especially in respect of the direction, the decision, and point number 2 of the order dated 20th July 2020. Is the matter. W for 98 is also same.
The same matter.
What is that?
obligement.
Lordship, here in this matter, I need to receive my instruction, Lordship. I'm seeking for 2 weeks further time, Lordship, in this matter, Lordship.
For proceeding?
My lord, more than 1.5 years has elapsed, my lord, since this honorable court has issued notice of motion, my lord. That they have not filed any affidavit and records will also be necessary. Lordship may grant them a last opportunity, my lord. Failing which, my lord? Because I am not receiving regular pension, my lord. I have challenged, my lord, the purported disciplinary proceedings, my lord, that was instituted completely behind my back. There is no material available with them, my lord, to show, even to remotely suggest, my lord, that I was given any opportunity to participate in the DP, so-called DP, my lord. No evidence, nothing. It's a farce, my lord. So under that circumstances, my lord, when the DP was initiated against me, my lord, I had retired. So therefore, my lord, the period under suspension, I was under suspension. The period under suspension has been treated not to be on duty by them, by the impugned order. First, way back in the year, my lord, 2019. Thereafter, I have filed departmental appeal. That was also not attended to, my lord. Finally, my lord, this petition before this honorable court. And they are not filing any affidavit, my lord. Record will also be necessary, my lord. So if on the next date, my lord, they do not file the affidavit and also do not produce the records, Lordship may make some observation, my lord, some stringent observation, my lord. Otherwise, I'm not receiving.
So, formally, as
My
per order dated 5/5/2025.
My lord.
The back day is fixed for admission hearing.
Yes, admission hearing. Admission, but their affidavit, either they will have to say, my lord, that they are not filing their affidavit, or my lord, they are filing their affidavit. That is where, my lord, I am stuck.
Are really interested to file the affidavit?
Yes, Lordship. Lordship, that's why, Lordship, I'm seeking 2 weeks time, Lordship. So we'll file, Lordship. before that.
I'm not receiving any regular pension, my lord. I'm an old person, my lord. I'm not making those submissions, my lord, those routine submissions. I'm a, my lord, specially able person, my lord.
I'm granting you 2 weeks time, but you pay some cost.
Lordship, not today, Lordship. If on the next date, Lordship, 2 weeks, Lordship, if you do not file, Lordship, consider imposing cost, Lordship.
Sir, purposely learned. Department. Anybody else for other respondent?
Respondent number 4, S.A. Hussain.
Yes?
S.A. Hussain.
That's a department. Or 4. Then.
Two will be, my lord, two will be by my learned colleague, government, my lord, pension department. R2, R2, my lord, respondent number 2.
Or 4 respondent. Or
The,
number 2.
the affidavit is referred to be filed by my lord, respondent 1 and respondent 3. More particularly by the respondent number 3, my lord. Director of Higher Education.
Mr. Dev Bhavita learned something for the development for 3 topics that may be granted from 1995 till. There is according to allowed, that's the matter. 30 seconds. 30 seconds. And on that day, Mr. Bhavita shall also produce the file relating to initiation of departmental.
If no affidavit is filed, my lord, if you also make some observation, I will be saved.
The affidavit of the total profit here and scope of the matter. Record.
I'm so deeply obliged, my lord.
Lordship, here in this matter, I am appearing on behalf of Mr. B. Gogoi, Lordship. Lordship, he is on lakes in port number 1. Lordship, here on behalf of respondent number 1 and 2, Lordship, I seek 2 weeks time to file an affidavit, Lordship.
Lordship, it has already been 2 years, Your Lordship, of notice has been issued nearly 2 years ago. Your
Lordship,
the last sons maybe, I am not against it.
Yes.
May be indicated in order that this is the last sons and the filed affidavit. Your Lordship.
Respondent number 3 has already filed, Lordship. So, Lordship, our health department, some instruction is required, Lordship, will bring it on record.
Third, sir, your good name.
A.R. Gogoi, Your Lordship.
A.R. Gogoi, learned.
Health department.
Health department.
1 and 2.
A Bora. A Bora for National Health Mission. Respond number 2.
It's that he has the inspection to raise the matter to rise cause is the matter after 2 weeks was to file the affidavit. Where it is accordingly allowed, raise the matter of COVID.
Obliged.
Obliged.
One, obliged.
Please, Your Lordship. Lordship, we have received instruction and our affidavit is also ready, Lordship. Next week, Lordship may fix, will bring it on.
In this case, my lord, in any case, my lord, with all respect, my lord, without he is a regular employee, my lord, pharmacist, my lord, without following due process of law, my lord, he was, my lord, removed from the service. So, my lord, they should follow the procedure, my lord, and we will place before the authority our case, my lord.
Let them file affidavit.
My lord.
S. Kemprai, Lordship.
S. Kemprai, the number.
Respond number 3 to 6. 3, 4, 5, 6.
4, 5, 6.
Time for 1 and 2. 1 and 2, Lordship. Health
1 and 2. 1 and 2. Kemprai, something is that. Or the affidavit for the respondent number. 4, 5, and 6 are ready. That would be filing
Next week.
next week. And press for listening the matter of 1 week.
Lordship.
After one, I.
Yes. 10 days, Lordship, 10 days, Lordship.
Where is according to the law? After that.
Find any date may be.
Okay.
Deep level.
May I please, Lord? So the petitioner before Lord is assistant teachers having B.Ed degree. Now, my Lord, whether the petitioner will get the advance increment for having that B.Ed degree, my Lord, number of litigation has been filed in this court. Now, as per office memorandum, my Lord, the petitioners are entitled one advance increment for having that B.Ed degree. And that office memorandum, my Lord, is at page 30. And by subsequent notification dated 22/10/2014, that benefit was, my Lord, cancelled by in 2014. Now, my Lord, that notification was challenged before this honorable court, and honorable court set aside that notification. So earlier benefit was started to given. Now, my Lord, as per that notification and that, my Lord, that another circular was issued by the government of Assam on 21/7/2016 at post 46, Your Lordship, I say. Page 46.
Yeah.
Then, my Lord, what happened, my Lord, in view of that, and another notification that page 48, subsequent.
Page 40.
47, my Lord, that is the, my Lord, 46, 47, that is one. That who is having the B.Ed degree?
46, 47, that's it.
Same. And who have obtained B.Ed degree and who has joined before 370, the advance increment will be given. Now, that
Attorney, you are agreeing?
Yes, ma'am.
now we
Here, there are two judgment parts.
Yes,
Yes, ma'am.
Earlier,
Malu was pleased to refer it to
yes,
the
division.
Honorable Division Bench.
What is the status of that reference?
Today it was listed before the Honorable Division, and Honorable Division was pleased to obtain the number of persons, how many persons are left to get the benefit, my lord.
Okay.
So, my lord, we fix it after it will be listed on 19th of September, my lord. 19th of September.
Let it be after making.
19 other meters.
Oh, yes, the division bench. After 19th.
Already they have
So
filed
there are,
my lord.
there are two decisions.
The opinion, two opinions there.
Yes. One is in favor of.
Yes,
and
in
the
favor
other
of us
is
and
against.
in favor of government.
But
That
the
is
against is prior in time.
Right.
And the second decision has not taken care of the first one.
after.
Therefore, it was referred to the.
Yes, that is correct. That is 3733.
Part of Hawk started. Applies this for that connect public method. What reference is pending to the division bench and the majority listed on 19th of September.
19th of September.
After the picking.
Obliged.
Is the after the open.
What problem? More wrong. What problem? May I please?
এটাতো অৰ্ডাৰ লাগি আছে আপোনাৰ এইটোতো আপোনাৰ ষ্টে এটা লাগি আছে
Where is your affidavit?
Affidavit I have not yet filed, Lordship. Some instruction I have already received, Lordship. So if Lordship permits, Lordship, it will take me 2 weeks' time to file my affidavit. Lordship, this is not the only case, in fact, Lordship. There are so many other cases on the same issue. So we are trying to coordinate amongst the all, Lordship. So in some cases, we received some instruction. In some cases, we have filed affidavit also. Lordship, one interim order is also there not to publish the select list without the leave of the court. In that case also, we are trying to file one vacating petition for publication of the result. That is why it is taking time. Lordship, I'm praying for 2 weeks' time, Lordship. In the meantime,
Let's the enter matter maybe.
check for it. It will file for
Sir, I'm not quite there, but
it will file for
it is it.
মানে গোটেইবিলাক মোৰ হাতত নাই গোটেইবিলাক মোৰ তাত নাই গোটা ডাটা দিতে
The Nayab submits that he has received record. And he will take record by affidavit. The price for 2 weeks time. Provided that it's not for 2 weeks. After
oblige, Lordship.
May I please, your lordship? Lordship, matter pertains to pensionary benefits from some incident, my lord.
And we allot time for instruction, my lord. 1 week time may be given.
file affidavit,
No, my lord, I have not received instructions, my lord.
you have not received.
Yes, my lord.
Is it please, lordship?
Respondent number
1345.
I am for the 6.
anybody for finance department or the order or that for the petitioner that Madam Joe Naipes,
DS new, your honor.
DS,
New.
but that nothing from the order is for 1, 3,
1, 3, 4, and 5.
4, and 5. That is the
6. I am 8 of property.
sales of property, but that the third is there, third is the respondent number. That, he has not seen that instruction and she files for this matter. After 1 week or 2 weeks.
2 weeks, your honor.
Lordship, kindly 1 week, your lordship, because it's a pensionary benefits was for missing person. He has been missing since 2013, your lordship. So my humble request, your lordship, after 1 week, if it's possible, your lordship.
1 week process, but whether she will be receiving instruction or not, that is after 10 days.
Deeply obliged.
The date will be, your lordship.
That's it.
Update for the paragraph for respondent number
1, 2, your lordship.
1 and 2
Yes,
present. That Madam Foreman for
I am for respondent number 6 and 7.
respondent number 6. This is the matter after 2 weeks, the event of subsequent of the
Obliged.
Item 26.
This is last occasion, management took time that they have received instruction file affidavit, but till today they have not filed affidavit. And regarding the CPS, the urgency in the case is since 2019, we have not received the salaries. And they said that they have post.
Lordship, further 2 weeks time may be granted.
Well,
File an affidavit, Lordship.
Last occasion, they said the instruction received,
Receive. We are
but 3 weeks time granted. Code.
2 weeks, Lordship. I'll file the affidavit,
Next week, you already fixed it. They are charging, we have not receiving the salary from 2019.
Yes, it's not started.
No further opportunity to defend.
But
6 to 9, Lordship. 6 to 9.
so by you.
And for aspect number 3, Lordship, on behalf of expert.
Appraise of that. We granted 2 weeks time to file the affidavit. Where did they go? After
6 a day, dear.
Obliged, Lordship.
Obliged.
Part after some time.
May I plead your lordship? May I plead your lordship? The petitioner is working as a Lat Mandal in Dhubri Revenue Circle, your lordship. He was suspended for a certain period of time. And during his period of suspension, a DP was initiated, and after a submission of report of the DP, he was reinstated in his service. But what happened during the period of suspension, his subsistence allowance is not released till now, your lordship. On last 2 occasions, they have taken time for obtaining instruction, your lordship.
Lordship, I pray further 4 weeks time, Lordship. Instruction is not received, Lordship.
I want to not receive my letter.
No,
This is the
if you
third
are
term.
not paying the subsistence allowance, so how he will subsist?
On last 2 occasions, already time was granted, your lordship.
Yes.
Lordship. Not receive any instruction, Lordship. That's why I'm able to say anything.
You are appearing for?
Respondent 4 and 5, Lordship.
Can you obtain verbal inspection why the subsistence allowance has not been paid to the petitioner? Will it take it up at 2 o'clock?
Lordship. This from Dhubri, Lordship. Then Lordship, next Friday, Lordship, next Friday.
Why cannot you obtain inspection for over?
It's from Dhubri, Lordship. That's why, Lordship.
Okay.
Lordship. Day after tomorrow, Lordship. Day after tomorrow.
Puri is doing Assam.
In Assam, Lordship.
Yeah.
Lordship. I will.
No.
Tomorrow, then tomorrow, Lordship. Tomorrow, Lordship. I will obtain. Tomorrow, Lordship. Tomorrow, Lordship.
Part
F is it. F is it.
F of it. Plus
8 Chakraborty.
part
4 and 5.
4 and 5 headache for
Or 1, 2, and 3 Lord.
1, 2, and 4. The Chakraborty is something that he has not given any instruction. The first for listening them method tomorrow. Accordingly, provided that the system method tomorrow. So as to input Mr. Chakraborty instruction from the respondent number 4.
Lordship. 4. 4, Lordship. District Commissioner. On tomorrow, Lordship.
Deeply obliged.
Obliged, Lordship.
Deeply obliged.
Sorry, my lord, I was in item number 23 to 25, my lord. I could not appear. I was on lag, my lord. So it's in the second half, it will taken in the second half. Item number 23 to 25, my lord. Otherwise, my lord, they have not filed their affidavit also. A date may be given after 2 weeks, my lord, in that period.
So later. The very important so but I talked for the beginning.
My instructions were on us.
MBA. And price for take the matter
On 15th of September, my lord.
15th of September. And if what they know that. Within 2 weeks from today.
Yes, election.
Well, Lucy.
May I please, your lordship? Lordship, matter relates to regarding non-payment of fire X allowances since July 2024. Lordship, petitioner is presently. Last occasion, department has taken time to bring instruction regarding.
Yes.
Matter pertains to lordship non-payment of fire X allowances since July 2024. Lordship, petitioner is presently working as constable or in BGTP Bongaigaon. Lordship, last occasion, department has taken time to bring instruction regarding.
Your
that,
lordship, I have sent the affidavit for vetting, your lordship. I have received this instruction. They have taken further time. It has to come from Delhi, your lordship. Lordship, kindly go.
Will they file affidavit regarding
Yes.
what instruction they have?
This is not instruction for taking time, your lord.
So when you will be able to find it.
Affidavit already sent for vetting, your lordship. It will come from Delhi.
That's all right. We cannot.
We,
extend the matter indefinitely.
Within, after 3 weeks, you know.
No, no. Why? Why not? The thing talking
For all, you know. CGC.
Only response.
Also response. What's up? Because the position has already been prepared. And that I think. And if I go the comparative. How about taking of the fact that the record over the update 2 weeks side of sense that is the better after 2 weeks.
What the date? Lords.
Oblige, your lord.
Lordship, this is related to a promotion matter.
My lord, the written instruction I have not received, but the telephonic communication I have received from the principal that in the last DPC, my lord, there due to some omission, my lord, the case of the petitioner could not be placed before the DPC because there was the late submission of relevant documents by petitioner herself also. But subsequently, my lord, it has been forwarded to the authority, government, my lord. And government had in fact issued a letter to the petitioner stating that her case will be considered in the next DPC. And her seniority or other issues that will also be considered, my lord. They have issued a letter to the petitioner. Just now I have received the instruction.
Lordship, there has been no letter as such, this thing, and we cannot rely on just verbal telephonic conversation. In fact,
that letter I have
there is
sought
no
for.
copy of the letter. There is
Your
no copy of the
may,
order.
your lordship may take up the matter in the next week, my lord. I will produce a copy of that letter, my lord.
Because I am already affected. 3rd May, 9th May, the order was given within 3 weeks. We are already in August. My juniors have already got promoted.
No,
There
my
is
lord,
no
after
letter.
that, no DPC has been held, my lord.
The issue is DPC will come only after the documents have been forwarded. I am affected because of the omission on their part. My juniors have got promoted. So I am the affected party. And we are in such a situation where despite 3-4 months having passed since the last order, the documents have not been forwarded.
Forwarded? It cannot be said. It has been forwarded, my lord, to the authority, my lord.
In case it has been forwarded, a copy should have been given to us.
No,
Uh,
why the documents will be
No,
forwarded to
intimation,
the
intimation.
government, my lord.
The intimation has to be given to the court. There should have been an affidavit.
My lord, your lordship may fix in the next week. I will produce the relevant letter, my lord.
Lordship,
That,
that's okay.
her case will
Monday,
be-
8.
Next month.
Next Monday, 8. That will be fine.
Or Mr. your good name.
DS Bhattacharya.
That's what the internet. So if you go out, all the respondent,
Yes, my lord.
all the respondent.
No, finance is also there. For finance, is it?
It's the case only have for the respondent finance department.
Thank you.
Respondent number 5. That's number 5.
Uh,
The pair made by Mr. Bora learned something. Learned stepping down the product on the 30. I suppose the method on next Monday was whenever products related by face. What was the content of the letter?
That her case will be placed in the next DPC, my lord, upcoming DPC, my lord.
Case of the petitioner will be applied in the next DPC. Pair of Mr. Bora is accordingly allowed. This is the exam method. Attention.
Yes, fine.
Much
Obliged, my lord.
Much.
Maybe your lordship. No, see, petition number 5, my lord, as we came to know from colleagues, my lord, expired, my lord. So, my lord, substitution petition required, my lord. Either we file substitute petition or the striking out petition, my lord, because he's from a remote village, my lord. We came to know from his colleagues, my lord. So, no proper instruction, my lord. It is true fact that expired, my lord.
Respondent number, petitioner number or respondent?
5, lordship.
Respondent number 5.
5, Omio Borgohai, lordship.
So you have not received any instruction.
No, my lord, no, my lord. He's
So
from a remote
when
village,
can
my
we
lord.
list the matter?
My
When,
lord.
when?
My lord, we already informed my lord. Not in like word.
After 2 weeks?
My lord. 2 weeks, my lord.
Or okay, correct. Then anybody for elementary education or elementary respondent?
Elementary 9. 9 is elementary 9.
If one appears, Lordship, his name may be.
Old if one is coming, lost, you kindly take it after. Huh? Then after, yes.
He can apply, my lord.
Yes.
Will record your name or?
Yes, my name is also there. Also.
Offered respondent. It's a spread. It's for 5.
5.
Omnia Borgohai property by C. And he has been waiting for instruction to complete the regular representative of the petitioner number 5. And price for granting to its time, there is a allowed after 2 weeks.
subject to your lordship, date may be fixed, my lord, subject to your lordship convenience, my lord. And maybe remain as a pardon, my lord.
No, no. Take it as front.
Yes.
May your lordship. Lordship, with regard to this contempt petition, we'd like to file an impediment for the new party. Not one office bearers, for the new office bearers, your lordship. Everybody.
Any amount has
Yes.
been released?
Oh, Lordship, this is the latest communication made to the Dibrugarh University now. There's some amount, Lordship, we have a finance approval is also required. That problem is there, Lordship. We'll reimburse them with their Lordship. Process is unknown, but since the amount is used.
But it will come upon our President.
Mr. Goswami?
Lordship, this has been received only today, sent only today, Lordship. But in the meantime, I talked to the university also. What has happened, Lordship, as I understand, just had a telephonic discussion, that the amount remains the same. Ceiling remains the same. In spite of, they will not be able to withdraw anything because the ceiling is around 1/12 of the annual budget. So from that, it's the regular salary and regular areas only. So this somehow will not work, so whatever. Unless the fund, extra fund is given, increased ceiling is given. This amount to the salary, this does not help the year. I think we need to wait for further instructions. Because some meeting at the Dibrugarh University was also in discussion with the, had come in fact twice for discussion the finance department. What I understand, Lordship, some meeting is being planned with the. Oh, yes, that's what I understand, Lordship, but this letter will not. Because without, they cannot withdraw more money, they do not have more money.
If this is the situation, then we have to get the proceeding.
No, Lordship, harder time will be required because we are just having
What
discussion.
other time?
We have been trying, Lordship, from our trying best to give the relief, Lordship, to give in terms of the incompetence of the honorable court order, Lordship. But some, because of the difficulty.
Lordship, there was an assurance on your part to provide the finance
No, Lordship, here just,
a few weeks back.
yes, Lordship, on the proposal, Lordship, here they have stated that the proposal has been sent on 18/8, Lordship. Lord, I'll get my instructions on this, Lordship. Now the proposal is.
You complete the
New income
person, will take a call on it. Pardon, sir?
T. Kashyap, your Lordship.
Pardon, then Mr. Kabil for respondent number, respondent number.
All Lordship. For higher Lordship.
The types of permanent complete as an job type. As party is which side?
Okay, 2 weeks time.
For what?
Yes, that's right. Higher education.
What time 2025? Adjust to the registered figure in
Yes, one.
To make payment, the existing charges for the part of the earlier Mr. Kusumi learning from one of the that he had received the letter today. And he may be granted some time to publish it. There is accordingly allowed read the matter after 2 weeks. Okay. But to obtain instruction.
But we'll also furnish our instruction because the proposal has, Lordship.
But you be ready to face the consequence.
No,
of
Lordship.
non-comply.
Yes, Lordship, here the proposal is being sent on.
We'll
Lordship,
see.
Lordship, can it be after vacation, Lord?
After vacation?
Yes, Lordship, and
We
it will
will
be too long.
any day.
Lordship.
Rest they will pick the day.
After vacation, will be more realistic.
Hold on. One line. Oblige, Lordship.
The expert of are of Mr. Kapiko,
1 to 4.
1 to 4 present. This the matter after 2 weeks. The event of subsequent presentation of the representative order shall follow.
Possibly, as per last order, they are supposed to place the inspection regarding the development taken place in this matter.
My lord, at this stage, my lord, the draft road has been endorsed to the legislative department, my lord, for vetting. This is the instruction.
So when the rule will be ready
My lord, matter may take up after 3 weeks, my lord.
after
3 weeks, my lord.
department, I have Mohan Bardai. Number
Lordship, Lordship, 6, 2 and 6. Mr. NJ Khatne for 2, I am for 6, Lordship. You mean NJ Khatne will be 2 and 6.
here for respondent for 2.
2, my lord.
16.6.
Yes.
You
2, my lord. I am appearing on behalf of NJ Khatonia, my lord.
can take. You can put for creating this. Here. Create for Mr. NJ Khatonia has 40 letter. Secretary. The of the sub department of school education. Address to the secretary, address to the standing council. Everything that the name of draft rule has been endorsed to the legislative department of the. And as a let's go listing the matter of her TV. And it would be allowed to place the matter of her TV. The letter published before the court will be annexer A. Shall be tagged to the report.
A date may be fixed or not.
Oblige, ये रहता है.
Take it from.
May it please a lot.
Yes.
Well, the issue relates to provincialization of the post of the music, the petition. She is at the verge of retirement. And petition was filed in 2023, notice was issued in August. 2 years passed by, no response from the government. And I want that 2 years they could not respond. If this is so, the plight of the petitioner is hanging and is going to be retired, whereas the long back authority found that I am eligible. This is there. I am eligible for provincialization, but nothing has been done. Lordship may, my respectful submission, post it next week. If they respond, they may respond, else Lordship will decide it on the basis of the available record. It may come up for admission column. Lordship will make it clear that if they want to respond, they may respond meanwhile. Otherwise, Lordship will decide it. 2 years is enough time. They are slipping over and litigants are suffering. And we claim of giving justice at the door.
Yes, Mr. Terampe, why affidavit could not be filed?
Lordship, instructions has not been received, Your Lordship, so I will not be able to say anything, Your Lordship, today.
Whether you have asked for any instruction from the.
Yes, Your Lordship, we have already shot for the instructions.
Instruction only five will be
Let the inspector of schools be present on the next day before his honorable court. Then the things will move. Otherwise, it doesn't pinches them. They do not have the conscience actually. Why they have not responded? Well, there's an expectation and there's a limit.
Heard Mr. K.K. Monto, heard a thing to consider assisted by Mr.
Yes, Gautam.
Heard a good for the. And also heard Terampe for the respondent elementary. Elementary or secondary?
Secondary, my lord.
Secondary part. So what they have for? Respondent number 2. Respondent number 2. Mr. Mohanto learned that no counsel for the petitioner has pointed out that notice in this case was given on 9/8/2023. And since then, more than 2 years elapsed, and the respondent authorities have failed to file their affidavit. And as such, Mr. Mohanto has contested this comment of hearing. And in the meantime, the respondent may file their affidavit. Where taking note of the submission of the Mohanto learned finding that it's the matter on audit.
10th, my lord.
10th.
10th, next Wednesday.
Lordship, can it be after 10?
No, I have serious objection, or they will not respond. Because they could not obtain the instructions still to me. Once, that is why I say, let the inspector or director be present here. How, why they do not respond to the letters written by our learned friend, if it is so? Was there any communication or not? These things, unless lordships cite up, will not move anywhere. Let it come up on 10th, let us see.
Okay. The maintenance is currently learned. Standing counsel for the respondent secretary department has to file affidavit in opposition. In the event of failing to file her affidavit in the court will proceed here the matter. Dispose of the same on the basis that it will place on record.
It will come up for admission column, Malak. Yes. Apply.
Apply.
May I please, Your Lordship. My lord, order dated 5/8/2022, still my lord, WTC number 4/97/2022 is not complied with my lord.
My lord, I am praying for further 2 weeks time, my lord. We have filed one IA, my lord, for review in IA in the division bench, my lord. That was some defects are there, my lord. We will clear within 1 week, my lord. Proceed may fix the matter after 2 weeks, my lord.
My lord, what happened, my lord, as per the direction of the Honorable Supreme Court, my lord, the state was allowed to file my lord, appropriate application for seeking clarifications of the my lord judgment. Accordingly, they filed the my lord IA for seeking clarification, and the honorable division bench of this honorable court has already clarified.
No, my.
So my lord, can only see the my lord judgment. Honorable Supreme Court is order, my lord, dated, my lord, 19/7/2024. If SLP was dismissed with a liberty to file, my lord, last sentence, my lord. With the liberty to the petitioner to seek necessary clarification, if at all, from the thereafter they file, my lord,
We
IA.
have filed IA, my lord, for clarification.
My lord, the second order is, my lord, the IA has been, my lord, disposed of, my lord. Disposed of on, my lord, 25/2023. 2022. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023. 2023
The IA has been disposed of.
My lord,
And
the
there is-
prayer of the IA was, my lord, what was we were seeking clarification for, my lord, the date. This IA is saying, my lord, the date of regularization, that is not disputed at all, my lord. Our clarification was, my lord, we seek clarification from the court, my lord, whether the qualification period, my lord, whether from the 2003 or from the initial date of appointment. That was short clarification, my lord. But Honorable Division Bench, my lord, was clarified that the regularization date is 10/6/2023, my lord. That is not disputed at all. We are not disputing that, my lord. That is why we have filed another review petition, my lord. Because our prayer was different, my lord, the clarification was given by different, my lord. My learned colleague is very much aware of that fact. I don't know why he is submitting like that, my lord.
My lord, because my lord, the petitioner is relating to the pension, my lord. So petitioner is, my lord, leading his life without pension since, my lord, 2021, my lord. Now he is in a, my lord, very, my lord, hardship position, my lord. And my lord, kindly see, my lord.
Let the IA be disposed.
Yes, my lord. That is why I am
There is no stay order from the higher court, my lord. My lord, the judgment passed by the honorable single bench, my lord, cannot be stopped, my lord. Let them pay at least, my lord, provisional pension, my lord. That can be adjusted, my lord.
My lord,
So that the petitioner can, my lord, at least, my lord, maintain.
that will be very difficult for us, my lord. We are not disputing that.
Provisional
we
pension,
get
my lord, there
pension.
is no difficult, my lord. It can be adjusted.
We are
my
praying
lord.
for 2 weeks' time. The division bench will clarify, my lord. We will proceed again, my lord. Otherwise, it's a huge
What
thing.
clarification you were requiring from the division bench?
Whether the period of the pension, the eligibility period, my lord, will be counted from his initial date of appointment or date of regularization. Date of regularization is 2003, my lord. And initial date of appointment was, I don't.
Then, my lord, kindly see the judgment of this honorable single bench, my lord. Kindly see page, my lord.
But in fact, the association was also, there was a case where the association of the secretary, the petitioners, my lord, employee, were filed, my lord. In that case, my lord, it was clarified.
No. According to you, from which state the petition is entered?
2003, my lord, the date of regularization.
The other
But the single judge's order, my lord, it was saying, my lord, it was covered by another case, my lord, first date of the case, which is saying from the date of initial appointment. But division bench order, my lord, it has been the observation, if you'll go through it, my lord, it looks like it's from the regularization. But
No,
at the end, my lord, the division bench said at that time that the judgment of the single judge will upheld. Thereafter, we move for the Supreme Court, my lord. Supreme Court, although dismisses, my lord, but Supreme Court also verbally said that it will be come from the 2003, my lord, from the date of regulation. It looks like, but
this verbal order will not.
no, my lord. That is why Honorable Supreme Court, my lord, given us liberty to seek clarification on that point. We have accordingly filed the IML for clarification. But our prayer for the clarification was, my lord, the whether that was initial from the date of appointment or from the regulation, that is 2003. But Honorable Division Court, in that case, my lord, clarified that date of regulation is 2003, which is admitted. We are not disputed that.
No,
That is why we are just praying.
Then why you could not point it out to the division bench that was the not clarification being sought for?
My lord, that was submitted, my lord, but in the order we have found little differently.
No, my lord.
That is why we have filed IA, my lord.
What happened, my lord?
I am praying for only 2 weeks time, my lord.
Petitioner initially appointed in 1993. His service was regularized in 2003. Then his service was again provincialized in 2006. That has been clarified whether it is 2006 or 2003. That is regularization is 2003. But for the pension of for the counting of pension, total length of service is to be counted. That is from his date of initial appointment till the date of his retirement. That is well, kindly see page 54. Page 54 is the division bench judgment.
That is his submission. But in their association's case, there was another case filed by their association. In that case, our court clarified.
Say, we are not concerned with the case filed by the association.
That is why,
concerned
my lord.
with the case filed by the petitioner.
My lord.
So what direction was it?
My lord, may I submit on that point, lordship's query, my lord? The IA we have filed recently, my lord, for clarification of the order of the division bench, my lord, the review, my lord. That will clarify everything, my lord. That is why I am praying for 2 weeks' time. Division bench will clarify, my lord, whether they are, my lord, the eligibility criteria will be counted from the 2003 or initial date of appointment. That is why I am praying for 2 weeks'
As
time.
application was filed in the guise of review, my lord.
Yes,
So
my lord.
second review is not, my lord.
Okay. Second review is not permissible.
That is
My lord, this is the first review, my lord, in the IA.
Let the IA be disposed of, there
Yes.
we'll see.
Yes, my lord, that is why.
Third, Mr.
M. Islam.
Third,
Yes, Dr. my lord, for the PNR, the
number.
respondents, my lord.
For the respondent, Sir. So, Lord, I think conflict for the September. Said. One, located at the part. The reason that spot clarification. Just to the entitlement of the pension by the entitlement of the date of pension. The entitlement of pension of the day of regularization of the service of the date of the the things under the application that we disposed of and based on the 2 weeks time there is a of which dictated
I love this, my lord.
Highly oblige, your lordship.
Well, here, in this case, my lord, I am appearing for sole respondent, my lord. I have received my lord, partial instruction, my lord. So I need some time, my lord.
again for the the border and then concept for the sole respondent. Present and substance here is partial effect.
My lord, not complete instruction, my lord. Here, only thing is that, my lord, his proposal has been sent to the government, my lord. We have received, yet to receive the confirmation from the government, my lord.
So when the proposal was sent,
My lord, this is this communication of 30 August, my lord. 15 days time may be granted, my lord. I'll try to bring the
for a comments that he may be granted 15 days time to obtain complete inspection. There is allowed this comment on COVID.
obligement.
My lordship. So, long pending lordship on last 3 occasions, that short time, lordship.
Well, here we have not filed a Ukalatnama, my lord. We have
My lordship, my lord, on 4/6/25, Learned Counsel Mr. Sisti said that complaints order, he will place the complaints order. Subsequently, they are taking different stance, lordship, on different occasions.
not different instead, my lord. I have received the instruction. Only thing is that we have not filed our Ukalatnama here. Hold on. Dada.
Earlier, the CP has appeared.
True, my lord.
Yes, lordship. On 4/6 and 6/6 on 2 occasions, Council Mr. Sisti appeared, lordship.
Well, 10 days time may be granted. In the meantime, we will file a Ukalatnama and we will try to bring our instruction.
Third, Mr.
NZ Chaudhary.
And that's the rural learner. Mr. Boda. Something of, response. Mr. Boda submits that the office of the respondent has not received a copy of the notice. For which the Katakama could not be filed any place for. After 2 weeks. However, Mr. Boda is granted 1 week time to file his Katakama and also to receive instruction. In respect of the compliance of the order, pursuant to the order of this court dated 4/6/2025. Place the matter on cover fixed that
Only thing is that my petitioner may serve a copy of the contempt petition to us.
Will serve extra.
order comes that the petitioner may be directed to furnish a copy of the petition. Sir, today, the text to furnish a copy of the petition to Mr. Boda during the course.
God bless you.
So far, item 36 is concerned, my lord. Narrowly means that item. Only name may be recorded, lordship. We have open instruction alongside. Yes, my lord. Oh, bless you.
Worship, here in this matter, the PPO has been issued and it has been complied with. And with regard to access drawal, which was there, in fact, your lordship, and that has been waived, your lordship. In the PPO.
It's a 2,14,433 rupees waived.
Wait. Because
PPO
in the
has been issued.
yes, PPO has been issued, your lordship.
Where is the order? Yes.
My lord, although my client has not received these communications, but if department has finalized the pension, it can be closed.
So every part a copy of the book letter.
Yes, I have already.
You have
I have already.
Third, Mr.
R. Karim, my lord.
R.
R. Karim.
Internet for the petition. Mr. Devi for respondent number.
I'm for respondent number 2, your lordship.
Number
Two.
Boda for respondent number.
1, my lord, on behalf of SMT 60, my lord.
Number 1. We have if the course of delivery of Boda has produced a record. By the joint director Pension Assam. Dated 29/8/2025 and commits that the order of this court has substantially been complied. And that the sum of rupees 45 4,570 has been waived. PPO has been issued. The learned counsel for the petitioners explained in view of the compliance, the order of this court in WPC number so the number
WPC number 2275 of 2024.
2275 of 20.
Order dated 1/5/2024.
Order dated 1/5/2024.
Lordship.
And the year of the WPC
2024, Lordship.
24. This conduct very close. Accordingly, taking note of the burden of both the parties. The letter produced by Mr. David shall be marked as annexure X and Y. Annexure A and B that shall be checked with the record.
Oblige, Lordship.
May I please, Your Lordship? Lordship, first of all, I deeply apologize because we had taken some time to file the affidavit. Sorry, wakalatnama, Your Lordship. But due to my medical illness, I was unavailable to file the wakalatnama since we have filed it yesterday only. Yesterday. Right. So
You have newly been engaged.
newly engaged. And
Your
if you are-
name plate.
Lordship,
Your name plate.
M. Sinha.
And learned counsel for the petitioner. Third, and learned counsel for the petitioner and with forward for the respondent number.
Respondent number 7. All official respondents 1 to 8, Lordship. 1 to
All
8.
the respondent. It's not something.
1 to 8.
Recently engaged, then we'll be filing her wakalatnama shortly and press for the matter after.
Next week, Lordship.
Sorry, a week. There is accordingly allowed press for the matter after 1 week.
Lordship, what?
Oblige.
Oblige.
My lord, we have gotten instruction that respondent number 1 is filing intends to file a review petition. So may I forward this?
When?
Or that order passed in the 22/1/2020.
Or it's a T also or for the petitioner.
T. Hazarika
T.
Or-
Hadurika.
for respondent number 1.
BTC.
BTC. For respondent number 1.
For respondent number 2, Miss P. Kakalari.
P. Hadurika.
P.
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 Oh, that's not number.
I'm not getting any copy.
For the respondent number 1. Subsistence. When a review petition is being filed, being review petition number. What is the number?
My lord, petition, my lord, review petition to be made, my lord, not yet made.
Not yet filed, Lordship.
Not yet
How
filed.
can,
File.
Not yet.
and Lordship, in this regard, this is a cleared action, Lordship. How can review petition file, Lordship, without informing me, Lordship? Review petition is till date not filed, Lordship.
Last order, Lordship, can you see last order in contempt petition?
Last order date 22/1/2025.
That necessary to appoint the teacher, Lordship, who got highest mark, Lordship. And they,
My lord,
I got court had directed that you appoint the who have got a highest mark. But in the BTC says that no, we have made appointment the who got lowest mark. This is our rule.
My lord, in BTC, it is form under, BTC is form under 6 schedule, so my lord, they want.
BTC can do lower mark candidates. It is the law.
Since it is form under 6 schedule, so they want to, their.
Let review maybe file, Lordship, if they want to file. Without filing review, that how can they contempt petition? Make statement, Lordship.
Like, that they are going to number 1 is contemplating to file one review petition against the judgment and order passed by this court in WPT number 6058 against the judgment and order dated 22/1/2025. Accordingly, he filed for this matter. After, when you are going to file the review?
Yes,
My lord,
that may be a
it may be adjourned till disposal of that petition.
You have not yet filed.
Yes.
Yes, my lord. We will going to file just after
When?
2 weeks, my lord.
And this the matter is after heat.
In 2 weeks' time. However, the learned conflict for the number 1 is granted 1 week time to produce the order in the review petition on next day.
Right.
Yes.
In 41, my lord, we have filed a writ appeal. And today, my lord, the Honorable Division was pleased to condone the delay. And it will be listed on 22nd of September. So may I pray that this content may come after? Today, the delay was condoned today, my lord.
Is yet to be registered.
Yet to be registered, my lord. So it will be listed on 22nd of September, my lord. So after that, may I pray the content may be listed.
Okay. Pardon, sir?
Yes, to the Lordship.
Yes?
To the
Yes, sir.
Director.
1 or 2 minutes.
Preferred. No, it's contemplating to preferred. 1. Appeal.
Appeal, my lord.
Appeal against the judgment and order of this court dated 27/2025. And the condemnation. Delay condemnation petition has been disposed of today. And if rise for this the matter after?
After puja vacation, my lord.
After puja vacation. There is accordingly allowed rest of the matter after puja vacation.
Lordship, date may be fixed, Lordship. Because the order passed on February, Lordship. We have not complied with the ill date.
Obliged, Lordship.
Obliged, Lordship.
Not yet for the petition or on the but they already started the concept for the
42.
Your
Content-
time, please.
Contempt petition, Lordship, order is at page 8, Lord.
That's all right. Your good name, please.
F Intas.
Yes, Mr. Garden of product, not that, but product. Yes, Mr. David.
Lordship, here in this matter, it relates to placing of the case of the petitioner before the DLC. So already now, from personal department, the instruction has been issued to consult all of the DLCs to place the matter. So they have, by this, it was on 30 August 2025, and have given 4 weeks of time, 1 month to all the DLCs. So in that aspect, taking that into account, I have also in morning conversed with the concerned DLC. They have told that we are making the necessary requirements for conducting the DLC. So taking that into aspect, so Lordship, can the matter be listed after 3 or 4 weeks? His grievance will be met. Her or his.
Mr. David, learned counsels for the contempt now. Subsistence. DLC will be sitting within a period of
1 month.
1 month. And if price for listing the matter after 1 month, it is accordingly allowed. List the matter after 1 month.
Highly obliged, Lordship.
May I please, Lordship? So it is a content matter, Lordship. So steps have been taken for service of notice upon the respondent.
Yes, madam, you are appearing?
Lordship, yeah, I'm appearing on behalf of SR Bora for respondent number 2.
I have the instruction to for APR for respondent 1 month.
Or, sir?
P does.
P does start at for the data for respondent number 2 and Bora for respondent
1 month.
Office note dated 22/8/2025 indicates that respondent number 3 has received the edit card has been received in respect of service of notice of contempt. But the respondent number 3 anybody from personnel, sorry, pension department, directorate of pension. David. Mr. David, the director of pension is respondent number 4 in this contempt.
Yes, Your Lord.
Do you have any instruction to appear?
Lordship, if the petitioner furnishes a copy of it, I'll can take the necessary instruction if Your Lordship instruct me so.
Okay.
For necessary.
Sir, David.
Yes, Your Lordship.
Present in the court. Connecting with some other matters than he is not. He may be furnished a copy of the petition, and then he will obtain necessary instruction from the Accordingly, it is provided that the learned counsel for the petitioner will furnish a copy of his petition or diary during the course of the day. Do you have the copy
I give him
today?
today.
The diary shall obtain necessary instruction in this regard. This is a list of matter after 1 week.
Yes. Lordship, may I pray for showing my name? Then I can know.
Okay, this is a reflect the name of Mr. Diary. About this.
Highly obliged.
Non-compliance of the order dated 7/8/2024, Lordship. Matter relating to pension, Lordship.
Or Mr. Gogoi, learned counsel for the petitioner. Office not dated 27/8/2025. Edit card in respect of notice in the respondent number 3 is back by the section. One entered appearance on behalf of respondent. The said office note also indicates that no notice. Neither edit card nor answer notice in respect of respondent number 1 and 2 has been received back by the section. You want to take fresh step or we will await service report?
Already I have taken, Lordship.
This is a list of matter after 2 weeks awaiting service report upon respondent number 1 and 2.
Lordship, may kindly peruse the Lozima Court's order dated 25/6/25. Service upon respondent number 3 and 6 are complete. And regarding other respondents, they have already appeared.
And Madam, you have for respondent number?
1, 4, and 5.
Let this matter come up for admission.
Mr. Bhattacharya, learned for the Madam.
M. Kalita.
And Lolita for
June.
respondent number 1.
Yes.
4 and 5.
4 and 5.
1, 4 and 5.
Shall we have for 2, I think.
5/6/2020. No. The order dated 25/6/2025 of the Lodges of Court. Notice upon respondent number 3 and 6 completed.
Yes.
Notice upon respondent number the rural income. This is a list of matter for admission hearing. After a week.
After. Obliged.
Receive the copy.
Yes, Lord.
Any of the
Let the case be kept pending. Malad.
or Islam.
Yes, Malad.
For the for 5. Sir, audit is better. For the edit, dated 30/8/2025. by which the addiction secretary has requested the director of electricity to submit and to verify details of the attendance of the petitioner in the same case and submit their salary and other relevant proof. The prescribed rules and procedures comply with order of 70. Okay. Wait. So, sir, here, when can we expect?
My lord, may suggest, my lord, may fix it before vacation, my lord. Before vacation, so that I can obtain the status regarding submission of area salary proposal. Because it will take some time. That is why, my lord, may fix it before vacation.
The attorney ordered at council put a respondent number 5. Submitted the matter may be listed before beginning. So as to obtain up-to-date status of the area salary proposal. Area salary and other relevant. Accordingly, it is provided that this matter on
25 mil.
25.
Yes. From 27 mil vacation start.
Mr. Attorney, the part is annexary. Will be take with the record.
Much.
Oblige.
Yes. Yeah.
Madam, on last occasion, Madam has directed the department to place instruction regarding current vacancy, Madam. With respect to page 47 of the writ petition. Madam.
So only 3 posts are lying vacant.
The postal lying vacant, they are for reserved category, Madam. SC, as mentioned there in Madam, SC, ST, and for chemistry, computer science and engineering, and mathematics, Madam. Others are kindly have page 40. Is the breakup, my lord. Per advertisement.
The Bora, have you checked it?
My lord, yes, my lord, he has submitted that, my lord. The already, my lord, 164 posts has been filled up. My lord, my contention is that, my lord, the kindly see the annexer 10, my lord,
Page 47.
page 47. This is the data.
It's 47 of your petition.
My lord, in my read petition, my lord, in my read petition, my lord, page 47. This is the data in respect of the post which were occupied by the part-time faculties, my lord. This is not the total data for the total against the total vacant post, my lord. This data is only for those posts, my lord, which posts were already occupied by the part-time faculties in the engineering colleges, my lord. In this data, my lord, page 48, part-time faculty engineering college engaged in the institution under DTE, and serial number 6, Johar Institute of Science and Technology, 24 posts. That posts were occupied by the part-time faculties. That is not the end point of the 24 is not the last vacant post of the GIST, madam. We are concerned about the GIST, madam. Because we were working as the electrical and telecommunication department as an assistant professor, both the petitioner in GIST, my lord. That's why, my lord, I am coming directly to the GIST, my lord. GIST, Juran Institute of Science and Technology, 24. That 24 is not the last number of the sanctioned vacant post in the GIST, my lord. In the GIST, my lord, in the year of 2008, my lord, the proposal has been submitted by the director, my lord. I am coming all things, my lord. What is going to be happen, my lord? This data has been shown only the post which were already occupied by the part-time faculties in the engineering colleges. That is 165, my lord. Out of 165, my lord, they have advertised 167 posts. 164 has been appointed by the regular employee, my lord. That is also not the correct, my lord. In the result sheet, my lord, 70 EF appointment has been made. Out of 70, my lord, serial number 69, my lord, I have annexed this annexes, my lord. 69, our post has not been advertised. For that, my lord, I will appear before your lordship, my lord. Lordship has passed an order. That post is still laying vacant, my lord. That is another thing, my lord. I am not coming to that, my lord. And apart from that, my lord, 165, so many posts is still laying vacant in the department, my lord. For the example, my lord, I just like to draw your attention, my lord. In respect of the GIST, my lord. This is not my document, this is the official document. This letter was issued by the director on 6 November 2008 at the time of the constitution of the GIST, my lord. Prior to that, my lord, this college was Science College, General College. Later on, my lord, this college has been converted to Technical Institute, my lord. At that time, my lord, in that letter, my lord, in the second paragraph, but in the first page, the following two branches are proposed to be introduced in the institution from the academic session 2009 and 10. That is electronics and telecommunication engineering. Number 2, power electronics and instrumentation. And accordingly, there is an annexer. So it is proposed to create 104 number of posts of various categories as shown in Annexure 1 with the effect from 1/2/2009 for the Johar Institute of Science and Technology. And kindly turn to the next page, my lord. That is the Annexure 1. Statement of the post to be created for the Johar Institute of Science and Technology.
Here, 22 posts have been shown.
37 posts, my lord. Lecture, that is 37 posts, my lord. I come here, that is on another page, my lord. That is on 20 August 2009, my lord. And another page is there, my lord. Loose page is also there. Bushe?
Yeah.
Lecture, later on, my lord, this post has been, their nomenclature has been changed as the assistant professor. 37.
So they have shown only 24 posts here.
Yes, so 24 posts were occupied by the part-time faculties. Another post, my lord, in the annexes, my lord. In the annexes, my lord, principal that has been occupied, professor occupied, assistant professor, that means associate professor occupied. These are the separate posts. Assistant professor 37, 24 were occupied by the part-time faculties, my lord. And now, my lord, one proposal has been submitted by the principal, my lord, before the government for additional post. And there, my lord, it is clearly stated, my lord.
Let this document be,
Based on correct fact.
but let this
No, no.
document be bring on record by way of affidavit, my lord. I'll reply because now, my lord, the petitioner is changing his case, my lord. Initially, the claim of the petitioner was that this annexure 10, my lord, page 47. Prior to engagement of incumbents under 3F, my lord, 165 posts were shown to be engaged in part-time, and where the name of the petitioners were there. It was their stand that out of 165, their name was also there. So their name was recommended for appointment under 3F, my lord. Since page, my lord, 66, since in the list of 3F appointment, their name did not reflect it, they said that since their name was there out of in 165 posts, their name should have been reflected in the newly engaged 3F appointees. Now, my lord, they are showing some documents which is not on record, and the plea and the claim of the petitioner, the stand is different, my lord, here.
No, my lord, because at that time,
And my lord, it is the government who will decide how much employee they require for one institute or not, my lord.
yes, my lord, that
They cannot say that these posts are vacant or you fill up those posts, even if, my lord. I'm not saying they are still vacant because I haven't seen those documents and I have to take instruction for that. But it
Madam,
is the employer who will decide best person to judge with how much
No, no,
employees.
the direction was to obtain instruction of
Yes,
whether
yes.
any vacant post is there or not.
Direction was, my lord, with my humble submission, my lord, on the basis of this annexure 10, because on last occasion, my learned friend has submitted that at the time of when the secretary asked the Directorate of Technical Education to submit the data regarding engagement of part-time professors, assistant professors engaged in different engineering colleges of Assam. That data was given, and which is at page 48. The specific case of the petitioner was that their name was there out of 165, or specifically in Jorat Institute called Jorat Institute of Science and Technology, 24. Out of 24, their name were there. And the case of the petitioner is that since the cabinet has decided that to engage those part-time employees under 3F, so their name should have been there in the list of 70 candidates who were engaged under the cabinet decision under the 3F pursuant to a cabinet decision. And on the basis of this, I have collected the instruction that out of this 65, now regular regular vacancy has been filled up by way of regular appointment, my lord.
Madam, my submission is that, my lord, we have filed this case on May, the month of May. Result has been pronounced in the 19 July 2025. At that time, my lord, the posts were not filled up. Now, on 19 July, my lord, posts were filled up. My lord, cabinet has decided, but a cabinet decision as per lordship's order 15/2025 is clearly indicated that cabinet is the decision is the only policy decision, and the department has no right to interfere with the policy decision. If cabinet has decided to 165 persons should be appointed in the TA, they have to appoint it. They have to appoint, but they did not do so. They have appointed only 70%. And we have been denied, my lord, without any reason. we have immediately come to your lordship after getting this order. And my lord, at this stage, my lord, he has said the result has out. He has said that all posts has been filled up, sanction post has been filled up. My submission is at this stage is that, my lord, not only 164 posts were laying vacant. In respect of the GIS, my lord, still, my lord, 24 posts is occupied. According to their proposal, my lord, I have submitted before your lordship. In their, my lord, it has been clearly stated that total number of posts of technical streams sanctioned 37. And there is a list, my lord. There is a list, my lord. On the list, page 4, PEI engineering, there 7 posts has been occupied by the assistant professor. 6 posts is occupied by the ETC, electronics and telecommunication, our department. Civil engineering 2 assistant professor, mechanical engineering 3 assistant professor, my lord. And out of 37, my lord, 24 posts has been, 2 posts has been already been filled up by the regular appointee, my lord. Now, where the rest of posts are still laying vacant. My humble submission is that, my lord, let them verify the existence of the vacant post in the GIS. If there is a post, my lord, we may be appointed under TF for 4 months, my lord. This is a temporary arrangement, my lord. Because there is a demand also, my lord. Shortage of the post also demand is given before the director, before the government. My humble submission is that, my lord. If required, my lord, I can bring it to the record, my lord. All things, my lord, what I have raised, because after that instruction he has submitted on today, my lord, then we become to know that not all posts has been filled up, my lord. 23rd, my lord, the advertisement, earlier advertisement 23rd, 2023, my lord. And as per that advertisement, my lord, appointment has been made on 8th February 2025, my lord. After 3 years of back, my lord. And in the meantime, my lord, this data has been submitted before the government by the director. And the government, they submitted it before the cabinet, and cabinet has taken the decision in the month of September that their post has to be converted to the TF. Since it has been decided in respect of those persons who were occupied the assistant professor post on as a part-time faculty, they are entitled, my lord. All are entitled to get the benefit of the TF as per the cabinet decision. This has been denied by the department by violating the policy decision of the cabinet, my lord. That cannot be done, my lord. It has been observed by your lordship's order dated 1/5/2025. While the similar situated person has been extended that benefit by your lordship's order. In that order, my lord, lordship will find clearly stated, clearly observed in paragraph 8, 9, 10, 11, 12, 13, 14, my lord. Clearly observe everything, my lord. That's why, my lord, we are coming before your lordship, my lord. Still, my lord, that post which were occupied by the part-time faculties 160.
Order dated.
Order dated, that is last annexes, my lord, of my writ petition. Lordship will find 93, page 93 of my writ petition, lordship. Operating portion, lordship, started from paragraph 8, 9, 10, 11, 12, 13, 14. At page 97.
Yes, sir. Yes.
My lord.
Sir, you file.
Lord, let him bring those documents on record, my lord, because those documents are not part of the record. Let him
Yes, sir,
file.
we can-
I'll in the meantime I will bring his stuff, my lord.
Let them also file a
Yes, yes.
total affidavit.
Yes, sir.
Yes, my lord. I'll take the documents. I'll in the meantime I'll also bring the instruction, updated instruction.
In the meantime, I still. Who's that?
But we were not conduct of for the basis of the but that is how. But the order that it the just like the 25. When I think that it from the product written instruction about the in various engineering colleges of Assam. And as per the state written instruction, out of 107 books, 164 books have already been filled up, and the state must fill up due to lack of due to shortage of candidates of the reserve category. And it appears that respect of Juhat Engineering College,
No, no, Juhal Institute of Science and Technology.
the Institute of Science and Technology, the number of posts have been shown as 24.
Yes, out of 37, 24 is filled up. Oh, 22 is filled up, my lord. 22 is filled up. Hello. My lord, 22 filled up.
In your document, is
In my documents,
which one has not been shown with respect of the rural
science and technology.
Gist.
Gist. ETC. Here, my lord, what I have submitted, my lord. Total, my lord, total. In advertised wise, my lord. Some advertisement were of the year 2023, so somewhere 24 out of because the selection process is all Assam level, my lord, not college wise. My lord may write in earlier, my lord has mentioned 165 posts in terms of Annex 10 of the my lord, writ petition. That is the data. That was the data in respect of the posts occupied by the part-time faculties in the engineering colleges. Not that the total strength of the vacant post.
The other hand, Mr. Borwa, learned council for the petitioner has brought in some document. On that altogether 50.
Altogether 37 posts has been sanctioned. Out of 37, my lord, 22 has been filled up.
In respect of
Gist.
this has been sanctioned. And out of the 37 posts, how many posts?
Only 24. Two.
22 posts have already been filled up and remain are yet to be filled up. In view of the submission to advance by Mr. Borua, learned counsel for the petitioner, Mr. Das submits that he may be allowed to take in respect of the aforementioned document and price for listing the matter on
22nd
September. Okay, it is accordingly allowed. The document produced before the court say by Mr. Borua. A copy of the document
Well, I will bring it to the record by filing an additional affidavit.
shall be furnished to Mr. Das learned counsel for the respondent authority to obtain the necessary and Mr. Borua shall also file an additional affidavit maintaining on record the documents he had relied upon. placed the matter on 22nd of September for further
Second Monday. Monday.